don't see a red button. There we have a red button. This is Tuesday, March 9th, 2021. Senate Judiciary Committee taking up S-25, an act relating to miscellaneous issues regarding cannabis. In preparing for today's meeting, I thought we would go over some of the recommendations from various folks who have spoken and who were witnesses on the committee, but also start by going through the bill and what we wanted to do. I will say from the outset that the agriculture issues within this bill do not belong in this committee. And that includes those suggested, for example, by the Vermont Growers Association and others. It's just not issues that judiciary normally deals with. So I think this should be in the purview of the Finance Committee and the Agriculture Committee. So I've asked Michelle to draft a note along with the proposals that are in this bill that have to do with finance and have to do with agriculture, and to ask the Agriculture Committee to look at those issues. I really appreciate the Growers Association and Graham and Rural Vermont and other groups and their suggestions. I'm not used to talking about current use and other things that are involved. I just don't think it's within the purview of the Senate Judiciary Committee. The social equity issues, I think, are within our purview. Government operations will have, I think, suggestions for us today or next, or hopefully by Thursday.
Well, we have some today that we've talked about and I think agreed on, and then we're continuing the discussion. We'll have them by tomorrow, I believe.
Okay, well, all right, so let's get started. Starting to go through the bill. Starting on page 2, regulation by local government. That's your committee, Senator White.
Yes, and what we've done is we have, we heard that do you want the details of what we've done?
No, I think if you're not going to be ready, I mean, I think if we put it together.
I think we're ready with this one.
Do you have is there ability to put a copy on the?
Michelle,
I can send your amendment to Peggy right now, and she can put it up if you want to talk about that. I wasn't sure that I didn't realize that Senate GovOps had already signed off on those. So, but I'll send it to Peggy right now. Do you want me to do that?
Sure.
Okay.
Peggy, I'm wondering where the copy of the bill would be on the website. It's
S25.
Yeah, it's not under today's documents.
No, if you go to the website.
Yeah.
Actually, let me show you guys how to do this.
You already did.
Oh, is this bills and no? Yeah.
Hold on. What happened there? Hold on.
I don't know. We did just.
It's not working.
It's under bills in the committee.
Yeah, if you go to the committee page.
Yep.
And you go under documents and handouts.
Yep.
And then you go under bill.
Okay, got it.
And then you go to S25.
Thank you.
And then drafts, amendments, and legal documents. It will be there. And so will the RAM amendment be there.
Okay, thanks so much.
No problem.
So right now, though, we're working off of the bill as introduced. Is that correct?
So far, yeah.
Okay, thanks.
So
now Senator White's got an amendment already to section.
Well, do you want us to do all the amendments at the same time? I can give you just the background of what this is. The VLCT felt that 2022 was way too soon because they won't even have the rules defined by then. So what we did is changed it and just said that it's similar to the liquor vote, that it just says that if a town hasn't voted on it by March 2023, it'll be considered an opt-in town.
Okay,
That's essentially what it says.
that sounds like a good idea.
And it doesn't give any language that you have to use on your vote. It just says that if you haven't done it, you're an opt-in.
And I emailed that language to everyone, to the committee, and also to Peggy, so Peggy can post it. But it'll.
Okay, this is not the way I want to go through a bill.
Okay.
It's almost impossible. Okay, I'll look at, this is the amendment that Senator White just talked about.
This is one
Okay.
of them. Yeah.
Okay, on March 8th, 2023, we're fine with that, right?
Yep. Oh,
This is
sorry.
just the retail portion. What about those that have asked for integrated licenses?
It says it on there. It's the retail portion of the integrated license.
Oh, thank you. Okay. Second amendment is a new section 2. That's the Cannabis Control Board duties and members.
And what we did is we took this out of the information that was given to us by, I believe, Jeffrey. I always want to call him Gregory, but it's Jeffrey. And what we did is the process that a member can be removed by 2 members of the board or by a 2/3 vote of the advisory committee. We then requested that the advisory committee be appointed by April 1st, and that by April 15th, they had their first meeting. Because if they're going to be an advisory board, they need to be seated before the Cannabis Control Board gives us the reports. Otherwise, they're not advising on anything.
Yep.
Jeanette, can I ask a question? Or
Yeah.
Senator Sears, can I ask a question? Is there any other board in existence that has this kind of arrangement?
I believe we heard that the PUC, was that what it was, Michelle?
Well, Joe, what with respect to what aspect are you talking about? What kind of arrangement?
Where there is no ability by the administration, for instance, to come in and say, we're going to remove this person.
Yeah, the Green Mountain Care Board.
Oh, that's what it was.
Okay.
And also, just to reiterate, but I know you guys are well aware of my office's position, is that what you did in Act 164 with regard to the structure and removal process, we feel is completely constitutional, well within your authority to do that. And that is, we differ from the administration's position that they are saying, they have consistently said that you can't do that, but we've had that battle with them a few times. But just so you know, we feel as though it's completely fine the way it is. If you want to add something here with regards to, you want to change something, you can certainly do that, but that's a policy choice and not a legal one as far as we're concerned.
Well, I think we've had this discussion before, and I know the committee doesn't want to design a bill based on whether the governor is going to sign a board or not. But I do know this provision and the opt-in provision are sticking points for the administration. And I'm just throwing that out there because it's something that I know.
I
And
appreciate
he
that.
said that we got the letter from Monica Hutt.
But this is the recommendation of the Government Operations Committee, so I'm inclined to go along with them personally, and we don't all have to.
I think that if you wanted to have the governor be able to remove it, it would have to be for cause. Many of the governors appoint the governor's appointees, he can just remove. But it would have to be for cause. You can't just have it at the whim of the administration.
Yeah, I agree.
Next, we have section 2 is integrated licenses. So can we accept that
We-
part of the strike all will be the government operations draft 1.1?
Well, Michelle, does this include all of the things that we're going to talk about this afternoon?
No, this amendment is just the first things that you sent me that you wanted me to put in an amendment. All the
Okay.
other issues you were going to discuss and then
Yeah.
decide on, and then I would draft and incorporate.
Okay, got it.
So
Okay.
Dick, you're back on S25 is introduced and looking at that
Yeah.
section 2 for integrated.
Section 2, yeah. Is
Right.
government operations going to have suggestions on that?
On the integrated licenses?
Yeah.
No, except that, we are looking this afternoon at, the suggestion that came from Representative China's about the Cannabis Business Development Fund and starting that up. And that was what, Philip, that was what I suggested we take a one-time advance and put in there. And then the dispensaries have suggested that they take into that fund would go 3% of their sales up to $50,000 for the first 6 months to put into that fund. And so we were going to take up that issue this afternoon, the development of the fund, and then the money from the dispensaries or the integrated licenses.
All right. The only thing I care is this was something the governor mentioned that I've mentioned, and we changed the board shall to may. I don't know if Virginia Renfrew has any comments on that, or anybody else in the audience who would like to comment.
Where is,
So I'm getting lost because the draft keeps disappearing from the screen.
This is no longer the draft. Now
No,
we're back to the bill.
Understood. The second half of my confusion is
Oh,
we're talking about discussions that have yet to happen, and then some drafts that have come in partial form. So I'm getting confused about what we're adding to the bill, because it seems a little premature.
This was actually in the bill.
Okay.
The section 2 had to do, the original section 2 of the bill,
Yeah.
S25, has to do with integrated licenses.
Mhm.
And the change is there shall be not more, that's a not is a change, than 5 total. And the other change is the board may issue rather than shall issue
Yeah.
an integrated license to the applicant. Virginia Renfrew is representing the dispensaries, medical dispensaries. I didn't know if she wanted to comment on that change. And then I was going to offer an opportunity for anybody else who wanted to comment on that. So it was one of the things the governor raised in his non-signing message. And the concern was expressed by some of the witnesses that integrated licenses could lead to big cannabis. And that's what has happened in other states, and it's something that I think we've all agreed we want to avoid. Is that, I mean, I'm going back to the bill now. The Senator White's finished with her draft.
Yeah, we haven't looked at section 2 at all. We're not going to.
So, Dick, I'm just wondering, I have from Michelle in my inbox, I have this amendment. Is that what we're talking about, or are we talking?
No, we're talking about the bill is introduced, page 5.
Okay.
At the line 2, changes, actually line 2 and 3, change the shall to a may. the idea there, as we introduced it, and Michelle can explain what the background is for that, but again, going back to the governor's non-signing letter.
So that one, Senator Sears is right. It's just changing it so that the board has discretion to issue the integrated rather than that they're required to issue the integrated if they meet all the criteria. One thing that's just important to note is that you can't, if it's discretionary and you don't know how many, if any, that they will issue, then that potentially eliminates the early rollouts of sales, because they're the ones that start selling in the spring as opposed to the retailers in the fall. So you wouldn't have any, if you did that and then the board doesn't issue the integrated, you could potentially just wind up with no tax revenue coming in until October instead of April of that year. And so you don't have an early rollout in that situation. So you have to think about how that affects your finances. It also means that the small cultivators that are licensed at the same time in the spring won't be able to sell to integrated because there won't be any integrated. So it does change the dynamic of the rollout and how fast any cannabis or cannabis products get to market.
So is that clear? So it's a policy decision.
Mm-hmm.
And Virginia and Jeffrey from the Vermont Growers Association would like to speak. Is that okay? Or do you have further questions, Bill? Senator.
I did have one quick question for Michelle.
Yeah.
You said it would change the timeline. Is it fair to say it could change the timeline because you could still have?
It's discretionary. So right now, the way that it is that if a dispensary applies and they meet all of the criteria and for everything, that then the board would shall issue them the license. It just changes it to discretionary, so they can or they can't. So we don't. It's possible it could go on, and all five. I don't know how many would apply, but it could roll out like originally intended as passed last year, or it could be fewer than anticipated, or it could be none because it's discretionary. And there's no basis, there's no standard in there for deciding whether or not to grant it. It's just you can.
That would be my question. So could the control board say, we think there should be fewer integrated licenses, so we're only going to take the first two that apply? Would that be in their purview to
Sure.
limit it?
Yeah, there's no basis for them accepting or denying it if they meet all the criteria. So they could do what they want.
Yeah. Okay. Thank you.
Mm-hmm.
All right. Just want to make clear, this was the governor's recommendation. Senator Benning and the other sponsors of the bill put it into the bill. Doesn't mean we have to keep it.
I can check with the numbers from JFO before if people.
No, I think I'd really rather hear from Virginia and Jeffrey, and then anybody else on the call who would like to speak. Virginia?
Good morning, senators. Thank you very much for having me here. It's good to see you all. So I'm Virginia Renfer. I represent the Vermont Cannabis Trade Association, which consists of the 5 medical cannabis dispensaries. And, we would prefer that the shell remains. The dispensaries would love to, be a partner with the state and be able to roll this program out sooner than later. And by leaving the word shall in there, it gives the dispensaries the ability to know that they will be licensed and they can start to, increase their production as they get closer to being licensed for this. And I think also the fact for the small growers, The dispensaries, definitely want to partner with the small growers. They support the language in S25 around the 25%. And, to be able to start to sell, obviously the timeline here has changed, but, if they could start selling, May, June, it will be bringing revenue into the state to help to pay for this. And I think it's important to know that none of the dispensaries want to be a monopoly within the state of Vermont. They want to be part of this. They recognize that in order for really the medical program to continue to survive, that they need to be in the tax and regulation field. So, we definitely would prefer that you keep the word shall. We understand, the governor was concerned about that, but we think it would actually benefit the state.
Questions for Virginia? Jeffrey, thank you for being here this morning.
Morning, everybody.
Morning.
Good to see you again. Thank you for this opportunity. Thank you, Senator Benning and others, for bringing up these amendments and trying to meet the governor in his concerns that he expressed last year. As you guys know, Vermont Growers Association, I'm the executive director, and we're part of a larger coalition. Some of my colleagues are on the call right now. I see Mark and Graham from rural Vermont. And we are here to help make sure that these inequities get addressed this year. Specific to the shall and licensees, my question was, and it may have been answered through Michelle of Ledge Council, and others who had commented, but we were really wondering, to speak from the small business, the farmer, and the entrepreneur aspect of this industry, which Vermont Growers Association represents. What do you guys anticipate materially changing for us if this were to become law? And I say that with some context, and that is, I understand Senator Sears, and thank you, Chairman, for bringing up the fact that our ag amendments are not appropriate for this committee. But I do want to mention, to speak to the governor's concerns, which you raise as intent for this clause, is we see the matter as a licensing issue. And so that is why we do propose licensing reforms, what we call equitable licensing. So whether or not this is the committee to be considering that, please note that is how we address those concerns that we're trying to meet now. So I did want to mention that. And very briefly, since Virginia brought up the notion of small businesses being able to sell to these integrated license holders, that is in the law. We do, from our own constituency, think that there may be some Vermonters who will do that, who are in that position to be doing that at that time. But we think a majority of the small businesses and the illicit actors will not be interested in lending their craft, their hard work product to be sold on the shelves, even if it's just 3 months, a couple months, in one of these stores that, to be frank, can be visited elsewhere. A lot of these large retailers, and that's fine, there's a place for them in this business. They have stores in Massachusetts, they have stores in Maine and elsewhere. So we're looking for Vermont brand. We're trying to transition Vermonters into this market. And so I want to remind the committee of the realities of contract growing and how that did not work out so well for brewers in the 1990s. So we think it's not a problem to be transitional, but don't rely on that for any sort of robust involvement from small businesses. So, thank you.
Okay.
So Can I just add something? So
Yeah,
that
I'm
would,
confused. Before you add anything, I'm a little confused. Can I ask Jeffrey a question?
sure, of course.
Thank you. What you're looking for is the licensing regulations and including that was section 2 of this amendment. Small regarding the small growers, licensing, marketing, equity, and scale appropriation regulation.
Correct. For instance, one of them would be an integrated license for farmers themselves.
Okay, so you'd like more than just, you'd like a lot, you'd like more than 5 integrated licenses.
Different types of licenses. So not entirely. We suggest defining other licenses as S54 or Act 164 does suggest, for instance, craft, delivery, and whatnot. It does allude to the CCB developing these licenses. What we're suggesting as an organization, as a broader coalition, is we've defined them now. We understand that this will meet the inequity and equality concerns that the governor addressed. So now would be the time to take it up. We've gone through the research and the study of examining other states and determining what we think is best for Vermont. And so that's what's in our proposal.
Thank you. Michelle, you wanted to say something?
I just wanted to clarify that that the small cultivators that would be the under 164, if you don't have, so as Jeffrey was saying, that he doesn't think that many would sell to an integrated licensee or a dispensary as provided in Act 164. So that means that those people that would have to wait till the retailers are licensed after October 1st. So the cultivators, the small cultivators that you granted an early access to licensing, if they're not going to do that, then they're not going to, I mean, I guess they can go ahead and get licensed, but they're not going to be able to sell product until the fall. So
I think I understand that. I'm not sure. All right. I mean, I'm looking at his licensing, market, equity, and scale appropriate regulation, one of which is to allow outdoor cultivation, caps on production, craft licenses, etc.
Senator Sears,
That's where I'm totally out of my league.
can I ask a question about that? My understanding is that we can put a lot of detail in here, or we can tell the Cannabis Control Board that they should be looking at craft licenses. And I actually prefer a CSA model so that a farmer can grow and sell to a limited, they wouldn't need to have a retail license because they're only selling to people who've signed up with them like a CSA. But I guess my concern is that if we put too much detail, I don't know how much detail we should be putting in here in terms of the licenses and what they mean and when they're granted, or if we should put that the intent is that we honor the small farm and the small growers in Vermont and leave that to the board and the advisory committee.
Well, all right. Well, I think we should put something in here that, at the very least, unless are you doing the licensing part?
We weren't going to.
Well, I think we should put something in here that allows them to grow outside. I don't think we should have all operations.
Oh,
small.
I agree with that. I thought you were going to send that to Ag.
Well, you know,
they're allowed to grow outside
Yeah,
now under current law.
they can grow outside. The suggestion here, I think, was that anything that's grown outside is be considered an agricultural product. And I'm not sure that I necessarily think that's a good idea, because that means there's no zoning, no restrictions on it. So, but they can grow outside.
Yeah, and yeah.
And there's a suggestion here that that there be caps, but at different caps for outside growing and inside growing and mixed light.
Well, that's
growing
what I need agriculture committee to look at. Okay, thank you.
So can I also I just wanted to direct y'all to, there is a provision in Act 164 that specifically directs the board to report to you next January recommendations as to whether the General Assembly should consider adding additional types of cannabis licenses, including a craft cooperative license, a delivery license, special event license, or others. So you guys did, because you had been talking about those other types of licenses the previous few years, and you chose not to do it in Act 164, but you did ask the board to consider the potential expanding of additional licenses. And so they're supposed to report to you on that already.
Okay, I'm into, Graham, do you have a comment? I just
Thank
saw
you. Yeah,
your hand. I'm sorry, I missed your hand earlier.
No, that's okay. I appreciate it. I'm here just trying to feed my daughter and listen at the same time. So I just wanted to provide a little clarity and speak to what Senator White just said as well. So it's just specifically, the licensing, if you felt like you weren't able or didn't have the time or ability to want to put in all the details that we suggest here, and I agree, we would love to see this in agriculture. Hopefully we can get it there and we can have a more nuanced conversation about some of these details. But if ultimately none of that turns out to be possible, one possibility is going in the direction, I believe, of what Senator White said, and being more specific about what we direct the CCB to do. So it would say that we could say something just similarly to the extent of the CCB shall create a licensing structure which defines and differentiates between indoor, outdoor, and mixed light, which differentiates different scales with different regulations associated with them and different costs associated with them, which has production caps for all scales of production in all types of business. And that way they wouldn't just be sort of left, well, we can do it if we want, but they'd be directed and said, you all have to sort these details. You have to create these sort of equitable playing field that involves scale. It involves indoor, outdoor, and mixed light. It involves probably differentiation of fee and differentiation of other types of regulation. I really appreciate the idea around a CSA model you brought up, Senator White. I think that's exactly sort of what we're talking about from the small farm perspective. Is the reality of a lot of small farmers is we can't make a living on our wholesale prices. And I think especially in this market, we've seen in other states, the commodification of cannabis really affects the ability of small people to exist in the market. So what ways are there for small producers to have a direct relationship with the consumer, which we currently all rely on for selling vegetables, in my case, beef, et cetera. So I just wanted to quickly comment on that. And just give you an idea of that you did mention the integrated license that we suggested, Senator Sears. And all that is essentially something similar to what Senator White is talking about, whereas it allows outdoor cultivation, processing, product manufacturing, and retail sales only on farm and only from product produced on farm, which is essentially what farmers are currently allowed to do for things they produce on their farm. And we understand that there's concerns around nuisance and around security and stuff. And that's hopefully what we could all talk about in committee when it gets to the Ag Committee as well. But I just wanted to comment there, and I think I'll leave.
I'm going to leave it to Senator White. If you want to put this in, I'm fine with it.
Oh, okay. We could, I actually think that the language that Graham was just using about the direction, instead of trying to be specific about the production caps and everything, is being specific to the Cannabis Control Board, that they need to look at this and they need to look at all these things in conjunction with it. So if you want us to do that this afternoon, we can do that.
I appreciate that.
Okay.
Senator Baruth has a comment or question.
I would just say there's a difference between what Jeanette just said and what Graham said, in that I heard him say he wanted us to say that the control board shall create this structure. I think Senator White just said that we would direct them to talk about it. I'm more comfortable directing a discussion and a decision from the control board because we haven't taken enough testimony for me to vote knowledgeably on a shall create this structure. Personally, that's my.
They have to come to us anyway, right?
Yeah.
Afterwards, yeah.
Well, your committee will decide whether to recommend a shall or a may.
Okay, I'm writing that down.
Wow. Graham, did you want to comment again? I saw your hand up, and I don't know.
Yeah, thank you. Yeah, Senator Baruth is correct that, you know, my point was it would be directing the Cannabis Control Board to specifically make those changes. And again, it wouldn't say that they have to look like this or they have to look like Y, but it says you have to make them based on scale, based on these definitions of indoor, outdoor, mixed light. And the reason we prefer that as opposed to what the alternative, just saying you must discuss this, is because we really would prefer to have these conversations with an elected body about the details if they're not going to be required. You know, if they're not going to have to create these structures, we just think it's going to be much harder for us to have those conversations. I know, with a 3-member board that's as opposed to in committee with folks. And this is Juniper who's providing testimony as well.
You heard her.
Yeah, I know.
I don't know.
I
if
agree with what
was
she
that in
said.
favor? Or?
She's supporting everything I'm saying. She's just very emphatic about it.
We say that something passes without objection. That's clearly an objection.
Okay. So I'm good with leaving this to government operations to give us some,
Okay,
as well as whether or not should be a may.
okay. Oh, on,
I mean,
On
shall. Well, the issue is that there's 2 issues in this section 2. One is the word not. There shall be not more than 5. And the other issue is, should it be a shall or a may? If it's a may, then it doesn't have to have a not. Or you could have it both. You could no limit on integrated licenses,
mhm.
which would set us up. But I'll leave that to your committee, Senator White.
All right.
Thank you for the volunteering. But I do. So section 3, actually, I wanted to talk about section, jump to page 6, where between August 1st and October 1st, 2020, 25% of cannabis flower sold by integrated license should be obtained from a licensed small cultivator. You want to look at that too as part of.
We can. We thought that the only thing that might need to change there is if available.
Yeah, but that would be also the ag. Once we got something, a shell here, I hope the ag committee will look at it.
That's tied into the integrated. So if they're,
Right.
yeah, so they do kind of go together.
Mhm.
The next is the social equity, which is section 3. I think, and Mark can correct me if I'm wrong, I think one of the recommendations was to have no licensing fee for certain rather than reduced. And that's in section 3A. And then in B, and then we come to Representative China's and Senator Rahm's amendments dealing with equity issues.
Can I ask a question on A? Are you leaving A, Senator Sears?
No, I'm asking a question. Which A in section 3?
A in section 3.
Yeah.
I'm just wondering, with regard to the line, who historically have been disproportionately impacted by cannabis prohibition. So does this include persons who resided out of state during that period of time? Or are these people supposedly impacted in Vermont, or can they be impacted in another state and come in and start here?
As I read this, they could,
There's
this is
no
the
definition.
board, this, yeah, go ahead, Michelle.
I was just going to say, so this is the term that's used a few times in Act 164, and that, but there is not a definition of that. And so the way that it's currently structured, it is up to the board, probably through rulemaking, that they would be identifying how they determine individuals who have historically been disproportionately impacted by cannabis. There's not a specific statutory definition of that.
So I guess I'm thinking about the board and all these pieces they have to address. I mean, might they not miss that? It seems like it should be a little more specific, but I think Jeanette had said at one point that Illinois had something, some guideline.
No, what I said is that Illinois had good, and Michigan also, I believe, and Massachusetts had good language, but their rollout and the implementation, from what I've heard, was not ideal. And I think this is something that the board really has to grapple with. And I was reading, if you read Representative China's proposed draft, the impacted area is all of Vermont, actually. But it isn't just Vermont, it's anywhere in the world, as it looks like. Because it says as determined by the United States Census Bureau. So it could be anywhere in the country. And then he has members of any impacted family are considered disproportionately affected. And that means anybody who had a parent, guardian, child, spouse, or dependent who was arrested for or convicted. I have to tell you, I know a lot of people who were arrested for marijuana in the 60s and 70s who are not disproportionately impacted individuals. They came from wealthy families. There is no way they should be considered there. So I think that the board has to really look at much more detail around what this means. That's my thought.
I mean, I would certainly think so too, because it looks like what is proposed here will be wiped out perhaps by others who aren't the intended, but.
No, I want to actually revise it so that I'll listen to Mark on but it should not be just reduced fees. There may be people who can't afford a fee who would be better off. So I don't think it should be just reduced fees. It should be considering no fee there in the board's recommendations. Mark?
Okay.
You have your hand up, Mark Hughes.
Good morning.
Morning.
Thanks for the invite, Peggy and Mr. Chairman, and good morning, committee and other guests and colleagues from the coalition. I think that where I wanted to start with just the observation that I have here is just a thought is I am a little uncertain on how to straddle these committees to get the work done, but I appreciate the invitation of both committees, and I appreciate you, Senator White, for the work that you've done on this so far. The other thought that I had is that there was some significant recommendation that was put forward by the working group of the Social Equity Caucus, and I was wondering if the committee had taken testimony or taken into consideration any of that. And then regarding the recommendations for amendment that were put forward on my last visit to you, They were just that. I think Senator Benning, you asked emphatically, are these recommendations for amendment, or are these recommendations for, is this a introduction of a bill? And I replied that it was both. So it is now H414. I have it in front of me right now. And these recommendations are to Senator Nitka's point, directly reflective of the language of Illinois, much of the policy of Illinois that really sought to address the racial and social equity aspects of the policy. I think that when I left the committee last, I was expecting that there would be all or some of the recommendations that were put forward that are contained here in H414, at least for amendment, or at least submit them on the appropriate place on the website to indicate such, but I haven't seen any of that. As far as the definitions are concerned about the identifying, who would be considered disproportionately impacted and otherwise, yes, there are areas that are identified. There are also family members that are identified as being impacted as well. And there are an array of different other definitions that refer to what would be considered a qualified social equity applicant. And I think that at the end of the day, that might be at the heart of what we're looking for is who is a qualified social equity applicant. So there are an array, again, of definitions that I sought to bring to your attention for consideration for implementation, amendment implementation, to clarify some of this confusion that goes with who is qualified. And I think that beyond that, I think just in practicality and just in acknowledgement of what some of us believe to be in existence of this thing called systemic racism, I just want to just flag that that in how we have approached this is that we've sought to identify folks as being impacted not solely because they were incarcerated, because what we know and understand, and this is the appropriate place to have that conversation in Senate Judiciary, is that the impact of an encounter with the so-called criminal justice system creates concentric circles, not just across a person's life, but across a person's family, and sometimes in perpetuity, and then even generationally. And that crosses state boundaries. Hard stop. So I know that is hard. It's easy to create policy in a vacuum, but we can't do that when we do it when we're having conversations about how systemic racism has impacted people of color. This is just from my perspective, from our perspective as an organization, because the vast majority of us come here from other states. That would also hold true in our health system, which was designed not to deliver health care in a consistent or a fair manner. But yet and still we bear the burden of caring for the people of the state of Vermont, no matter where they come from. And I think that we could say the same thing about housing and education and employment across all other sectors. And one thing holds true, and no matter how you look at it, is that.
Yeah, thank you. No, go ahead. Did I interrupt? I'm sorry.
I was just I thought you were going to say something. One of the things that we have to look at is simply that this state is 94.5% white, and it used to be more white. So these policies, if we view these policies in a manner in which we're taking into consideration who has come from out of the state, I think we're doing a lot of folks a disservice. In fact, the vast majority of you didn't come from Vermont. So when we go to the policy itself, 25, I want to just go back a little bit, Mr. Chairman, and talk a little bit about the additional responsibility that the committee, that the Cannabis Control Board rather, has concerning the work of equity, and that there's a responsibility that, again, as we go back to this language, historically, individuals who have historically been disproportionately impacted, page 1, line 13, 14, 15. This is a responsibility that's being placed again on the Cannabis Control Board. And I think this really echoes the concern of some of the folks who are communicating, these ag issues, is that there's an awful lot that we've placed on the Cannabis Control Board. And I realize that this is a tough policy to put together. And there was some, there's quite a bit that the Cannabis Control Board is going to have to carry when it comes to equity. That's when it gets challenging. And if it's a matter of process, I can understand wanting to offload, or for lack of, I should say a better term would be to delegate with the responsibility to report back some of these very important responsibilities. But when it comes to equity, those responsibilities, I believe, should rise to a level that we address them as early out of the gate legislatively as possible. Because what we see and what we know is the more discretion one has in these areas, the more difficult it is to achieve equity. So I implore you, if it's possible, to Senator Beirut, I see your hand, I'll yield.
Mr. Chairman, if I might.
Yeah, go ahead.
I agree with you, Mark. And that's why when we talked about this the last time you were with the committee, it seemed to me that the language in Representative China's bill could inadvertently produce a result where the great majority of people who were helped by the language were not the community you're referring to, but instead, other people who had been maybe narrowly impacted by the war on drugs, but not as directly. And that goes to the fact that the language in Representative China's original bill didn't refer to race. It referred to people who had been socioeconomically impacted within a certain geographic area. And it seems to me that if we don't want to repeat the experience in states that Senator White mentioned, that we should be more directive about what we mean. Otherwise, it's possible to imagine 94.5% of the money and the resources going to white Vermonters who may be part of a far-flung network of people who were impacted by the war on drugs, but we wouldn't be addressing systemic racism as you're talking about it. So can you help us in that way because I think one of the issues we're coming up with is specificity. And I remember Skylar Nash in his testimony urged us to speak directly to the issue of race. How should we do that?
Could I throw something in here for Mark to also consider when he's talking about this?
Uh-oh, got more than one thing to consider. I better start writing.
So Alice Senator Nitka's question about if this would be from any place, and I think that it's clear, if I remember it from Act 164, that you have to be a Vermont resident in order to get a license. That doesn't mean that you couldn't have come from someplace else and been impacted there, but you currently have to be a Vermont resident, as I remember it.
But,
Okay. No, that's not.
Michelle's
So-
disagreeing. We
so I
thought that
think-
was unconstitutional, I think.
Okay, but
if
I
I'm
think we want to make
remembering
it pretty
correctly.
clear then that, in my opinion, and maybe Mark, you can think about this also, is are we going to give preference to people who have no ties to Vermont at all, but just see that they can get a reduced fee or a loan here, but have no ties, as opposed to people who actually are here? And I don't know how you do that if it's unconstitutional. So, but that is something.
No, I think what we determined was it would be unconstitutional to say that nobody from another state could get a license.
Yeah.
I don't know that it would be unconstitutional to provide certain benefits to Vermonters that aren't available to non-Vermonters.
Oh,
And
okay.
you do that in 164.
That's
You
what I thought.
You provide technical
So
assistance.
I think, yeah,
through
we
ATCD.
could provide a benefit to Vermonters from marginalized communities.
Yeah.
It's how you define marginalized communities that
Yeah.
is my worry looking over age 414. And I will be honest, I don't know that we have unfortunately this year, a lot of bills have come late, and it's hard to, deal with it in 7 days, believe me. So, Mark, I believe that
Okay.
the question from Senator White has been answered.
Yep.
I think
Thank
the
you.
question is how best to define a marginalized community or a community member without, I guess that's the question, without insulting anybody.
Right. I appreciate that, Mr. Chairman. And before I speak about him, I should go ahead and acknowledge him. Senator Benning is trying to get in the conversation.
Senator Benning?
Mark, you used the word emphatic about my last conversation, and I think you were kind. I was exasperated, actually, because this is a heavy issue. Trying to deal with it under what could be considered an arbitrary date called crossover is very difficult. But I want to give you my thoughts in hearing what Philip's offered direction was. I personally was arrested in 1975 at a time when I had long hair and I played guitar in a rock and roll band. I didn't smoke marijuana. Some of my band members did, and they targeted the house that we were playing at in order to raid it and make a demonstration in my town. I don't think, looking back, although I had some severe problems at the time, looking back, I did manage to get into law school and pass the bar, so I came out okay. I don't think that I would fit the definition of anybody's intent here of having some socioeconomic disadvantage. But I know a Vermonter who was on the path to being a 30-year employee of the United States, and 3 years before his retirement was popped on a marijuana charge. And as a result, they not only fired him, they deprived him of his pension. Now he's a white guy, and I think he would have, at least the way I had understood this, he would have an argument to make that he should fall into the definition of having a socioeconomic impact. So I'm wrestling with how do you do this and not have people becoming upset because they've been deprived of at least making that argument. And I haven't read, I think you said it was H414, but it seems to me that this discussion is a lengthy one. And my frustration is I'm not sure how this committee is going to be able to resolve it in the limited amount of time that we have left. And so I want you to know that what you described kindly as being emphatic still comes back to my exasperation. It is a conversation that should be had, decisions should be made, but I don't want to leave people at the end of the day who might have a valid argument to make being deprived of making the argument to the CDC just because of the color of their skin. That would disturb me greatly unless we are taking this as solely an issue of systemic racism and eliminating everything else from the equation. And I think that's where Philip wants to go, if I am hearing him correctly. But it would be hard for me to support that concept, knowing that Vermont's population was so heavily dominated by white folks. And at the same time, they have had a socioeconomic impact in some situations. And I don't understand why they would be deprived of making the argument that we're trying to advance here.
I appreciate that.
You've got an awful lot that people have thrown at you, and hopefully you can give us some thoughts.
Maybe the House can correct it all.
That's why we're in Senate Judiciary, because here you can fix everything. So as long as I'm here, we will, before I leave, this will all be resolved. In fact, so will world's hunger.
Yeah.
So I want to go back briefly to Senator Benning's last statement, because I think it's really important before we get to Baby Ruth, and it all interconnects. And I think some of this, quite frankly and respectfully, is education. It is. I think there's there's a couple blind spots that we all wrestle with. You can talk about systemic racism, and you can talk about correcting it in ways that don't necessarily specifically point out race. I think there's ways you can do it where it points out race in addition to other things. I think Senator Benning, that, and I am in agreement with Belaine and Schuyler from last week as far as what we should try to do. But we would have a different argument if that were the case. It may be from another demographic, it may be from another group of folks, but we'd have a different argument. What the United States has been able to do governmentally and skillfully, and probably starting as recent as Nixon and mastered by Reagan, is to talk about race without talking about race. The other thing, and also to create discriminatory practices that hold people back without necessarily talking about race. I think we all know and understand that. We also know and understand that as recent as Fisher versus Texas, that the 14th Amendment will, create some problems in this conversation. I think nobody knows this better than Senator Benning. So when we start having conversations, and we do know when we start looking at what happened down there in Texas, is we do know that race can be considered as one of some of the criteria that one can consider in making a decision like this. So there's nothing wrong with us in doing so. But what we also know and understand, and this is what the courts will support, is when we start doing this work, when somebody comes at us sideways and tries to peel this thing apart, we got to have something to stand on. And I think that because we know what systemic racism has created in this nation, we know that most Black people are poor. We also know that most poor people are white. So there are descriptors in here that gets at the problem. And yes, I do think we definitely need to add, an additional descriptor that speaks to, American descendants of slavery and also the further group of Black and Indigenous and other people of color as one of the criteria in this policy. But yeah, I think that the language is here. The definitions are here. And I think before we went down this road, what I was really trying to state more than anything is that it is important that we try to do as much of this work in providing clarifying language in terms of definitions and also identifying objectives in terms of racial equity on the upfront legislatively, as opposed to deferring to a three-person group of folks appointed by the governor later on down the road to make some of these really heavy decisions. Now, this also pertains to ag as well. So when we're talking about, who's making decisions on qualifications, who's making decisions on access, and I think we're almost there, I guess, is what I'm telling you. And I see this arbitrary deadline here on the 12th coming up. I don't know if there's any money in this. Maybe it's the 19th. But I see that coming up. But I think we have everything that we need in front of us to make some of these decisions. I see that, Mr. Chairman, that there's an opportunity for us to incorporate some language surrounding definitions. There's an opportunity for us to incorporate in this policy some programmatic language that came out of Illinois, as Senator Nitka had referred to as well, and to be able to get some of this work done on the upfront. Maybe we can leave some latitude for the CCB to potentially modify some of this work at the recommendation of the advisors later on down the road. But I think we have the structure in place. At this stage in the game, I think we have the language to insert in this bill to make sure, that we can meet the governor on this, and that we can get some work done legislatively that will satisfy these equity desires that this committee and those of us who are in our constituency share. So I will spare you from going back through this policy, because we've been through this policy before, and Senator Sears had indicated that he hadn't seen the H414, but we actually, vast majority of it, and Michelle would have to correct me if I'm wrong, but I do believe that H414 was largely the draft policy that we reviewed last time I was here.
Thank you. Senator White.
Could I just, this has gotten me more and more confused, because when I read the definitions that were in, and I don't have 414, so I don't know how it's changed, but in the draft that I had, the definitions, the impacted area is really all of Vermont. It's if you look at there's 5 different criteria for an impacted area, and that really probably only leaves out the hill in Burlington. Every place else is really part of one of these areas. And then if you look at member of impacted family and the criteria for
sorry, can I just find that first? So you're saying that
on the draft it's on page 5 is the impacted area, page 5, and on the draft the page 4 is page 3 and 4. So if you look at the qualified equity applicant, it means somebody that's resided in one of these areas and who is a member of an impacted family or has been arrested for or convicted of an expungable crime. That means that Joe Benning would be considered one of these social equity applicants, or his daughter would be, because he lives, my guess is that Lyndonville is either a Vermont Opportunity Zone, or 75% of the children are in federal lunch program, or 20% of the residents get food stamps. And he was arrested for an expungible crime. So he would be eligible, as would his daughter or his wife, to be considered a social equity applicant. And I know plenty of people who fit into that category of having been arrested, maybe not even convicted, but they were arrested for an expungible crime, and they live in one of these areas, but they in no way should they be considered a social equity applicant. So how do we get this down so that we're really, and this is what I think one of the problems was in Illinois, is that they had the language, but it wasn't tight enough that they had all these people who qualified. And how do we get this tight enough so that, and I don't think it should be just race. I think race should be one of the components, but there are plenty of poor white kids from Vermont who were arrested and who have been impacted dramatically. So how do we do this without allowing, and I'm not picking on Joe or his daughter, but because I don't feel comfortable naming other people, but
Well, I think that I've given a lot of thought to this, and I've tried to not get too afraid of what I'm about to say, but I think what we're really talking about, and what you're talking about, Senator White, are racial and cultural minorities. People, I'm thinking of some of the towns that I represent. They're very, without identifying the community, there was an industry in that community that resulted in a number of trailer parks in the community, and people moved into those homes. And then when the industry left, the parks were still there, and very low income people. Some of them were people who were racial minorities. Some of them were certainly considered cultural minorities. I don't know how you define that, but I think that's what you're looking at. And I realize I may be using terms that are old fashioned or whatever, but really, when you talk about, it gets to making sure that we're not defining. I think you have to use those terms without using the racial term. Minority, I don't think.
I think you can say race is
Yeah.
one of the components. I
Yes,
think you can
but
do that.
the second part is, how do you make sure that these folks were disproportionately impacted by cannabis prohibition?
And how do you define who those people are? Because they primarily were poor kids, rural poor
Yeah.
kids,
Right.
or kids from St. Albans. Because if you read whatever that book was that
I mean,
I can't
Paul
think of his name.
Lawrence.
Yeah, I mean,
Yeah.
if you a bunch of those kids were certainly impacted, and so how do you define who those people are without saying it's
Some-
the poor kids?
Some
Well-
could define themselves.
Huh?
I mean, certainly some could define themselves. I can think of a former member of the House of Representatives who is a Rutland County person who was picked up in that Paul Lawrence scandal, and it was a major, major deal. I know several of them who were.
Right. I meant, how do you define it so
Well-
that you keep out those other people like Joe and his daughter
Right.
and
Well,
the people that I'm referring to?
I mean,
Well, maybe that's the struggle.
do we let people self-define? I mean, how are you going to sort this out?
I don't know. That's
Other
what I'm
than-
asking.
other than the things that
Mark,
it said very directly to put in.
must be frustrating for you to listen to.
Well, I'm getting used to it. I've been at this for a little bit, but I think it's a good conversation. It's being broadcasted, it's being recorded, and there's a lot of stuff that my senators are unpacking here, and I think that's important. And I'm starting to learn that some of this is part of the process. The process is important. I thought I'd never say that, but here we are. I think that this is a teachable moment, though. I do think, I think that, when we go into our prisons and we see that our prisons are 11%, Black folks, and when there's 1.4% Black folks in the state, and with the high conviction rate or the technical, getting hit on technicals with marijuana historically, not just now, but over time. And then if you look at the nation, because again, we're not just talking about Vermont, we're talking about the nation, because we just already established that people come here from all over the place. We talk about what marijuana has historically and is continuing to do to Black and brown folks across the United States. We've got to contextualize this conversation. And, I said earlier that most Black people are poor and most poor people are white, but you have to think about what the term disproportionate means. It's very important, to have that conversation. We can always find something that's anomalous. Senator Benning, with all due respect, you are anomalous. The situation that you encountered as a state senator, as a qualified and competent attorney, having encountered what you encountered, that is an anomaly. I have a rich brother. He's an anomaly. So I think that quite frankly, we spend too much time in these conversations talking about anomalous circumstances, when we ought to be talking about, what is historically disproportionate, and if we can't sit here and forget about 1865. We can't sit here and forget about who we are as a nation and what the so-called justice system has done to people of color and how marijuana has played a role in that. So yes, I do. Again, I'll go back to the point I was making. I think it is important that we do include race in these definitions. And it is one of the criteria. And who knows, maybe some white people might slip in this because they've also been disproportionately impacted. This is not an exercise of trying to figure out how to keep white people out. It's an exercise of trying to make sure that we address those who are disproportionately impacted. And yes, our target is those folks who are American descendants of slaves and folks who are Black, Indigenous, and other people of color. Why? Because that is what the system has historically disproportionately impacted. Those are the facts. So I think that that's what this policy is designed for. I think that, if you were to say, by looking at this policy, that the entire state, if you were to say, and I were to agree that this policy addresses the entire state, then I would, if we were to agree on that, then I would say, good, 1 down, 49 to go. So, and here's the other fact is that, that criteria is, must be held in combination with other criterias. And we must look very closely at how that criteria, how that definition is used throughout this policy, because it's not used throughout this policy as the criteria to qualify anyone for anything, okay? It is a criteria. So I think we need to look closely at the policy, and let's be careful not to explain the policy away before we do the deep analysis that's necessary. If we don't have time to do the deep analysis now, to Senator Benning's point, then let's continue to do the deep analysis. Let's take responsibility for it, but let's not put it on the control board, because we're going to get what I believe is a poorer outcome if we kick this one, if we punt this one.
Right. Okay, so historically is a key word. Disproportionately impacted is a key word. And so I think we need to come up with better wording. I'm going back to section 3 in the bill.
Okay.
You're in the bill?
I'm in
And as introduced.
the bill as introduced, S25. It has the term historically have been disproportionately impacted by cannabis prohibition. It has that twice. And obviously those who seek to participate in the regulated cannabis market. So I think,
Okay,
and Michelle, as we play with the wording here, I think we need to have race be a part of that definition. Racial, however you want to put it, however, that's, we already have seen it before. So it's, but I think we're also talking about people, other individuals who may, socioeconomic or whatever, have been also disproportionately impacted by cannabis prohibition.
There's,
Am I off? Did I go off did I go off
No.
here? No.
No.
What
Is
if,
what we're talking about?
what if we, I mean, I think there's going to be some confusion here about we're putting something in and then H14 is going through the House and they're going to
That-
come up with some
That's,
definitions
I
and
can't
stuff.
deal with what the House does.
I know.
The
So,
House will, I can't call them any names, but they
I know.
will do what they do.
so my,
Well, you can, but only I get in trouble.
I realize that, Senator Benning.
my
you can't do it
suggestion
on
here
TV.
is, I don't know if this makes any sense or not, but can we expand this just a little bit to include race in here
Yes.
and socioeconomic status? And then,
Yes.
and then tell the board more specifically to work with, and we can name groups that they need to work with to come up with clearer definitions and criteria. Because if we just say those things, that sets the direction for them. But then we define certain groups that they need to work with in a subcommittee to come up with some more detail around it. I don't know if that makes sense or not.
Okay, so if I was wording section 3, I would have whatever we come up with, and I think it's better to move on from this now and to try to come up with some wording and the next time we take the bill up. But right now, I'd like to consider reduced licensing fees and low or no interest loans.
Mhm.
To
Yeah.
these groups. So that's in B. And then I want to discuss the idea of a certain amount of the revenue, up to $10 million, going into I know some of you didn't like that idea from Senator Ron's bill, but
Mr. Chair,
yes.
I will say as a general idea, when the bill passed and the governor allowed it to become law, it committed a couple of streams of revenue, one to substance abuse treatment and one to after-school programs. I would support both of those. I think they're both worthy. But I wish the process hadn't pre-committed those streams, because I think to the extent possible, it makes, oops, sorry. Sorry about that.
Well, I didn't.
It was my phone going through my headphones.
Oh,
I think to the extent possible, it makes sense to have one coherent discussion about where the money should go, as we do in the money committees, where you're able to judge things against one another and make a coherent decision. So if, having committed 2 revenue streams, we in this bill commit another one, what we're doing is piece by piece, we're leaving less and less to have that important discussion about the big needs we have in the state.
I understand.
So not to downplay this need, but to say it should take place in the context and sit beside other needs.
Okay, but I would say that we already crossed that Rubicon when we passed the bill with money in it for substance misuse and the after school one, blah, blah, blah. And seems to me that signaling 20% or $10 million, either in the way, define it in the way it is on page 2 of Senator Rahm's proposal or any other proposal, but 20% of the revenues, and I was going to say up to $10 million, be used for criminal justice counsel in conjunction with Racial Justice Alliance, Migrant Justice, National NAACP, municipalities in Vermont to engage in community-based process related to policing and public safety, prioritizing for communities that seek to reduce their police force and transition funding away from policing towards other personal and programming that can need it. Put in any wording you want, but it would go to dealing with some of these significant problems that we've discussed now. That was my idea. That would be C. You don't want to, that's not popular with the rest.
I disagree with that. I agree with Philip that we should not be specifying more funds. And if we do put some funds into it, what this, our committee is looking this afternoon at what was suggested by in Representative China's proposal, which is a cannabis business development fund that would go for technical assistance and small and loans. It would be for the technical advice, business advice, and loans to people. That's very different than money for communities who want to transition away from policing. And I think that
I didn't say transition away from policing.
that's what
please.
the amendment says. That's what her amendment says.
Well, that's not what I would have in mind.
But so anyway, I do not think that we should, I'm fine with doing an upfront amount into a business loan, a business fund, whatever we want to call it, for loans and grants and to individuals, but not to communities, but to individuals who are some of the impacted individuals. That's where I would think we need to look.
Jeanette, can I ask where you would get that money from?
Well, we're suggesting an upfront, and I think I suggested that before, just an upfront appropriation this year to get it, to set up the fund and get it started so that people can begin to get technical assistance and loans and grants. And then there was a suggestion that a percentage of the sales from the dispensaries go into that fund up to a certain amount. So we're looking at that. That was in both proposals. And then ongoing, it would be come through the appropriations process, just as funds for how much we put into loan forgiveness for nurses comes through the appropriations process. And so there would be an appropriation that would be put in there. And it could even at some point be a revolving loan fund for those people who find that they can pay it back. Or it could be grants if that's what needed.
Thank you for that. I guess I've got to say, Dick, I'm very uncomfortable trying to add any revenue streams from what we're trying to set up here beyond what we've already sold the bill on, which was pretty specific. And it is difficult for me to, especially knowing how few towns have voted to actually have something established. It's difficult for me to go back to the folks that I've argued this bill should pass and say we're going to dilute from those law enforcement and therapeutic or prevention efforts that were the selling points for the bill in the first place. So I'm going to have to agree with Jeanette on that.
Well, I think if a certain percent, I will argue again, a certain percentage went towards embedding social workers in community policing efforts, would make a huge difference. I don't mean I never intended to defund police. Have always intended to make sure that the money's going and being used in looking at different ways of using that money, like social workers and others.
But that isn't what the amendment says.
I understand. Okay, thank you.
Uh,
Mark, did you have a comment? And then I'll listen to Philip. I'm sorry, Philip, Senator Baruth first and then Mark.
Yeah, if just briefly, I'm not prejudging the merits of what you're talking about, Mr. Chair. It could be that in a larger discussion that rises to the top. I'm just suggesting that there should be a plan for a larger discussion before we commit more piecemeal. And that's a good question, I think, for, we have 3 members here who are also on appropriations. We have the chair of government operations. There should be a plan that we can all agree to when we have this conversation.
Well, I'm going to tell you that one of the things that happened when the governor and the state police talked about having a social worker embedded in every district in the last state address or budget address, I can't remember which one. Local police departments contacted me saying they would love to have the ability to get grants to start funding that in their police departments. So that's what I'm talking about. And so whatever.
Well, just to surface my own preference there, I've been contacted by hundreds of people around the state college system who are hoping that will be a lifeline going forward for them. So
childcare wants a dedicated fund. The pensions want a dedicated fund. The state college want a dedicated fund.
No,
where does that leave? Where does that leave this?
Well, it should leave it, in my opinion, in what I said. We should create a moment purposefully with the right mix of committees to take a look at this problem. What should happen with this revenue stream?
Mark, thank you. I'm sorry, Bill. Did I?
No, that's about it.
Mark, you've been.
It's pretty frustrating. It's pretty frustrating to be having this conversation right now, given the history of where we've come from, not just historically, but even as we work to put this bill together this last year. Couldn't seem to get a word in edgewise. There wasn't a word about systemic racism or racial equity in any of those 3 reports that were produced that informed S54 at the top of last session. And it was very difficult to get anyone's attention. It seemed that there was a lot of commitment to getting this done for reasons that we understand, because of, where this process has come from, also because of many of the folks who are either big cannabis or folks who are dispensaries or folks who are affiliated. And it was just a lot of power. And we saw a lot of vitriol that came from folks that sought to oppose what we were putting forward this last year. So we waited. And the governor was, teetering, and he also agreed. And now we're at a conversation about I must frame what I'm about to say, because what underpins systemic racism is a differential in political and economic power. And now we're sitting and we're having a conversation about how we're going to pay for it. And this really comes down to priorities. We were hoping that this would have been figured out last year. And the reason why you have placeholders for other things that you are paying for is because you prioritized it over racial equity in this process. And so this is much larger than, our experience in the criminal justice system. It's the disparities that exist across all systems of state government, to the extent that the median wealth of a Black family is 1/13 that of a white family, and diminishing. But yet we have this conversation. I think that, again, I think most of this work should be done now. I think the system was not designed to accommodate it, because there is a vacillating between who actually is responsible for this, because Senator White in government operations just indicated and said earlier that we would be talking about this in her committee later. This is that whole that piece that goes into the work that would be done with the integrated licensing rather, in the equity program. This is the same conversation. It's the same conversation. It's how do you fund, how do you fund social equity grants? How do you fund the Cannabis Business Development Fund? These are the same conversations. One's going to be in government ops this afternoon. We're having one now. A little while ago, and I said it at the top of my opening statement, I told you that I have confusion with that. And the reason why this is this system wasn't designed to accommodate a conversation on systemic racism. I want to again urge the committee to take a close look at, it keeps being referred to as Brian China's language, but it's called H414, and we proposed it. So there is a policy. It does have the language that suggests how to go about paying for this. It does speak of transferring $200,000 into the Cannabis Registration Fee Fund. It speaks of 10% of revenues raised by the cannabis excise tax, not to exceed $2 million. It goes into the work that Senator White is going to be taken up in her committee this afternoon on integrated licenses. It talks about those fees that would go into that. So there are ways that are established whereby we can pay for this work. And yes, representing American descendants of slavery and BIPOC communities, it would be at most advantageous for us to have these monies being routed into our communities for our economic development. That nobody's talking about anything else except for the ability to advance economically. This is just a market. This is one market, and this is one that's emerging. And now is the time to be able to find the money to be able to create those programs. And I think that there's a framework that's right here in front of us in H414 that establishes that. So I hope that you take a closer look at that and consider it. And I will be in testimony this afternoon to talk more about it as well, if that's what I need to do.
Thank you, Mark. Moving on, we anxiously await what happens in government operations. Section 5 of the bill has to do with the Vermont Criminal Justice Council. that the A-RIDE program. That's just a report. Is that okay?
Yeah.
Section 6 repeals the section, and it's replaced with Section 7, the substance misuse prevention funding, and this is just to put a fence around the funding so it doesn't go to other places. The language, I believe, came from joint fiscal, if I'm not mistaken, and Michelle working together on this.
So it doesn't change anything substantively from,
No, it just says that they have the carry forward ability. So they don't spend 10 million in 1 year. They have they only spend 8 and they've got 2 million left. They can spend 12 the next year.
okay,
Is that correct?
Right. It also codifies the language. In Act 164, it was session law. So we codified that. Anthea is actually the one that works on the money provisions on the cannabis stuff for us. And so I think, and she went back and forth with Senator Sears a bit on trying to figure out, there's issues around you, as you well know, you can't bind a future legislature. And so the governor had said he wanted it to be in a special fund, but the legislature did not want to do a special fund. And so this is just trying to codify it and also clarify that if there's any revenues left over, that it carries forward and it can't be or shouldn't be pilfered.
but it could be not withstood in the future.
I would imagine so. I think you'd want to talk to one of the money team attorneys like Anthea, because that's not what I do day in and day out. But I do know, obviously, the general rule.
But even if a special fund can be withstood,
Yeah.
we have a special fund for the marijuana, the medical marijuana fees go into a special fund. And this administration took that money and used it.
Yeah.
During a deficit. So I don't think even if you create a special fund, it doesn't mean it can't be not withstood.
Yeah.
Can I ask a question on another?
Yep.
On page 6, this is page 6, section 3, the additional sentence between August 1st and October 22nd. What I'm interested in there is sold by an integrated licensee shall be obtained from a licensed small cultivator.
Yeah,
So-
that went along with section 2.
Yes, I'm just wondering though, can that small cultivator be from out of state if there isn't enough being grown in Vermont?
No.
No.
Or should it say a Vermont licensed small cultivator?
Well, there's no buying cannabis in another state and crossing state lines, though nothing in the whole system contemplates that. It's all when we talk about licensed cannabis establishments, it's always just talking about Vermont licensed cannabis establishments.
All right.
I think that would probably be federally illegal.
Yeah.
Doesn't mean someone wouldn't do it.
Well,
it'd be a violation of both state and federal law.
Okay,
Nobody would ever do that.
right.
That,
Okay.
I wish I had a gavel that could say that completes the orders of the day.
You can say it.
Um,
what
Mr. Chair.
time is-
But
what
Well, I
what
wanted
time
to-
is it?
I'm sorry, did somebody say something?
Oh, no.
It's
I just
Mark.
thought-
Mark, yeah, go ahead, Mark.
I was wondering, just briefly, I know you're getting ready to get out of here, but I didn't feel resolved on the social equity thing. Can we just kick that entire conversation to GovOps with the senator's permission and come back and with how we flesh that out, this section 3 in conjunction with the other work that we're doing with the
Absolutely. if it's okay with Senator White.
Senator White, is that fine with you?
Sure.
Well,
Okay, I'll see you this afternoon.
Yep.
Senator Baruth has
Mark framed that in a way I just want to clarify. GovOps could bring back language to us, but it would then be for discussion and
Yeah.
vote in here.
Yeah, well, I understand that. I appreciate the clarification. And, you know, I appreciate the process. I'll leave it there.
Okay.
Glad
you.
you do.
As far as the memo to agriculture, Michelle, just the sections that we just identified that are agriculture, as well as the issues that were raised by the Growers Association and by Rural Vermont, we would ask them to look at those issues. And we need to put, this bill's got to go to finance. It's got to go to appropriations. Thank you. Peggy, I think we've pretty much finished with what we're going to do today, and sign on of YouTube.
Okay, we have to think about Thursday and Friday, don't forget.
Peggy, I know we do, but do we?
Thank you, Peggy.
Thank you, Peggy.
Just a friendly reminder.
I understand that we're still live.
Yep, do you want me to